Hello, my name is Ty Wilson, and today we're talking about deposition preparation and some helpful information. And we're going to really cover today what you should not do if you're in a deposition. And we're going to start off by talking about answering the questions. You want to answer the questions that they ask, not the questions you think they want to know, the questions that they ask. And so what does that require of you? Well, that requires that you listen completely and attentively to the person who's asking the questions, which is going to be the opposing attorney. You want to listen, understand what they're saying, and if you don't understand, you want to ask, I'm sorry, I don't understand your question. Can you rephrase it? They will happily rephrase it. If they cannot rephrase it appropriately, even your counsel may step in, as I've done in several cases, and say, I think what they're asking you is, and get clarification. The most important thing is that you understand what it is that you are asking under oath. Prior to the deposition, you're going to be sworn under oath. Everything you say will be the truth, the whole truth, and nothing but the truth. And so that is something that is very important. It's very critical. And so you do not want to guess. You do not want to mislead. You do not want to lie. You want to be truthful, and you want to get through the deposition as quickly as possible. Some other notes that we've made is you don't want to talk endlessly. So when they ask you a question, you want to answer that question and answer that question only. You don't want to dance around it. If they say, tell us where you live, 123 Main Street, Nowheresville, Georgia, 300,000. Not the address. It's a ranch style house, all brick all around. I've got a little creek that runs in the backyard. Our neighbors are really great in that neighborhood. No. Answer the question only. If they ask you where you live, the better answer actually is Nowheresville, Georgia. What is your address? Make them ask you the specifics that they're looking for. If they don't, that's on them. That's not on you. Don't volunteer. You're there because you're required to be there. You're not there because that other attorney is your buddy. They have something they're doing, and they're requiring in order for you to obtain some form of benefit, whether it's medical benefits or income benefits. And they are the ones who are in charge of helping guide the person who makes the decision as to whether or not you get that. So they're not your buddies. At the same time, this is not a yelling argument type situation. This is not what you see on TV. It's a question and answer session, and it should be, and it is usually very civil. And so you just want to get in there, answer the questions, and get out. Now, a lot of times we get questions about what can they ask? Well, arguably, anything that's relevant they can ask. And so arguably that's anything under the sun. Certainly it's within a certain degree of measure. That's why you have an attorney there. That attorney is listening to the questions. I know I've sat through thousands and thousands of depositions. Your attorney has likely sat through several. I doubt it would be their first deposition. They're listening to the questions. They're listening if it's proper. If it's not, can we move on? Can we go off the record? They'll handle that. That's why you brought them on board. So let's move on. Doing a deposition, I guess that brings up a great point. And doing a deposition without an attorney is probably not a good call. You don't know what you're required to answer and what you're not. That attorney will be in there to protect you, will be in there to say, okay, let's move on. Hey, this is not relevant. This is why it's not relevant. And if you go into a deposition not knowing the rules of evidence, not knowing what they can or cannot ask, chances are you're going to answer those questions, or you're going to answer nothing. The deposition will take forever. You'll get a conference call with the judge, possibly a motion to compel, and several other things. So it's critical that you, at least if you're going to be going through a deposition, have an attorney there to sit in and help at least protect your interest. Another mistake that we see a lot is giving more information, which kind of covers that first one. Answer the question only. Don't give more information than what is asked for. As the deponent, the person being deposed or in the deposition, you're the one to answer questions. Another thing we see is they say, well, why are they asking me that? Well, I've got some questions for you, Mr. Attorney. Not the time to do that. You're there for your deposition. You brought forth a workers' compensation claim. The other attorney has the right to ask you questions under oath, and that is in fact what they're doing. So you don't have the right to ask questions in your deposition. You, with the help of your attorney or on your own, can seek to take someone else's deposition. That would be someone who is potentially a party in the claim, not necessarily the attorney. And so a lot of times it's highly unnecessary. And so it's not the time to ask questions. It's the time to answer what you've got to answer, get in there, get out of there, and get on with your life. All right, let's look at some other ones we've got. Another thing that I would say not to do in a deposition, if you do have an attorney, is to listen to the question and then look at your attorney. It's almost like you don't know what to say. You're concerned. You keep looking at the attorney. And if that's done over and over again, a good attorney on the other side will say, I notice you keep looking at your attorney every time I ask you a question. Is there something you need to speak with your attorney about? And if so, I just ask that you answer this question and we'll take a break. Otherwise, please let me know why you keep looking at your attorney. It is kind of a nervous habit. You want to not do that. It's your conversation with that other attorney. They're asking questions. Your attorney will jump in, and if the attorney has prepared you, which all of them should, they will put their hands up in front of you if they want you to hold off on saying anything, make their objections, and then they'll say, yes, you can answer that question. Go ahead and answer that question to the best of your ability, or don't respond to that. And then the attorneys will have their little conversation. It'll all be on the record and so forth. Now, you're gonna hear off the record, on the record. What does that mean? Well, technically, when an attorney says, let's go off the record for a second, what they're doing is they're telling the court reporter to stop recording, stop repeating everything. As the deponent, you can never count on them being quote unquote off the record. That's really something for the attorneys. And so you don't want to say anything off the cuff or anything like that on the record or off the record. As the deponent, you're being judged at that deposition by opposing counsel. And so the best behavior is to be on your best behavior, is to be really quiet. And even if the other side is talking, your attorney's maybe gone to the restroom or getting some water or something, and you're in there one-on-one, they may strike up some general conversation. I always tell my clients, you don't necessarily need to engage in that conversation. You can be pleasant, but keep it very light. If they ask you anything about the case, you say, I need my attorney here before I respond, and you leave it that way. We hope that some of this information has been beneficial, and that if you are going into a deposition, you know kind of a better idea of what not to do. You want to get in there, you want to get out, and you want to answer the questions that they have to ask you to the best of your ability, under oath, truthfully, and move on. We hope that information's been helpful, and we will see you on the next video.